Well, welcome back to the Cordell and Cordell Virtual Town Hall. I'm Scott Trout, and as always, being your moderator today. And we're going to be talking about something important, and that is it affects a lot, 51% as a divorce rate, and that is my wife's left me, now what do I do? And it's always, one of those panic moments. And it is all about having a conversation with an attorney who practices exclusively in family law like we do here at Cordell and Cordell. And we continue to bring you this type of virtual town hall where you have an opportunity today to ask questions live and get answers from our panel of Cordell and Cordell attorneys like every other day. Make sure you do that. You can submit your questions right now in the chat section. In the second half of our virtual town hall, we'll get to those questions and hopefully get you some answers. But always keep in mind that it is not legal advice. We can't give you legal advice from here. Your facts, your circumstances are always particular, and they're very varying and different from case to case. And so the only way to get proper legal advice or any legal advice whatsoever is to schedule a consultation with an attorney. You can do that with any of our attorneys across the country. We have offices throughout the United States and including the UK. You can go to cordellcordell.com, or you can call us at 866-DADS-LAW and schedule a consultation. Happy to meet with you, give you the proper legal advice that you need. And the only way to get that is through that consultation. So go ahead and schedule that. But again, go ahead and submit your questions in the chat section or in the Q&A section, excuse me. And when we do get to those, make sure to just put first name and a state. And if we have one of our attorneys in your state, we'll try to toss that question to them and try to get you some direction so they can facilitate a good conversation with an attorney when you schedule that consultation. Many of you may be in the middle of your case. We'll also have questions with regards to that, as we always do. So I'll continue to remind each of you to submit your questions. And if you don't want to do it today, you can always submit them to town halls. You can email them, and we'll address them either in future virtual town halls or podcasts. And if you haven't listened to our podcast, we'll do that twice every week. You can subscribe over on Apple, iTunes, and listen to our podcast where we just address for 15 minutes or so a topic relevant to guys before, during, and after divorce. So today is no different. Again, we're going to talk about my wife's left me. We're going to give you some practical things to consider and some topics to have conversations with your attorney, again, who practices exclusively in family law like we do. So let's go to our panelists, and then we're going to get right to it. Again, submit your questions in the Q&A section right now. Let's talk with Cassandra out in San Diego. Welcome.
Hi, Scott. Thank you. My name is Cassandra Lelek. I practice out of San Diego, California, and I'm lead litigator for the firm. I've been at the firm for 4 years and have been practicing for over 11.
Thank you. And now let's go to Kansas City. Matthew, welcome.
My name is Matthew Peters. I'm an attorney in Kansas City, Missouri. I've been practicing family law for 5 years and an attorney for 7.
Great. Thanks, Matthew. Let's go to Rebecca over in Baltimore.
Hi, Rebecca Ripley in Baltimore, Maryland. I've been with the firm for, it'll be 10 years in January, and I've been practicing for 15. Welcome to all of you.
Thanks. And rounding out the panel for today as we continue on My Wife's Left Me, Now What? We're going to go to Nicholas in the Atlanta metro area. Welcome.
Hey, thanks, Scott. Nicholas Granade over here in Georgia. I've been with the firm about 6 years now, opened the office over here in Fayetteville, and happy to be here today.
Well, great. Thanks all for joining. We'll get right to it. But first, we want to go ahead and do a really quick break, and we're going to be right back after this quick message.
New school, new job, new home. Change is hard and can leave you feeling isolated. And divorce delivers one of life's hardest blows. The relationships you counted on are suddenly gone. But you don't have to walk through this alone. We can help. For more than 30 years, Cordell & Cordell has guided men through the challenges of divorce. You're not alone. Call Cordell & Cordell, a partner men can count on.
All right, so when that happens, you've been served with papers, or perhaps your wife has threatened, I'm going to do something. And I've said this repeatedly over the last almost 20 months that we've been doing these virtual town halls. One of the first things that I'm asked, typically, I'll get a client that calls, and they say, my wife's moved out, or should I move out? There's animosity in our marriage. I don't know what to do. And I always like to start there, because the decision on this critical question often has significant ramifications on everything else. It's really the beginning. And before we get there, I'm going to go to Cassandra in just a second, but it really emphasizes when I talk about this topic and probably everything else, you really need to have a conversation with an attorney because every decision you make, they do have significant ramifications along the way. And this is no different, Cassandra. That is, many guys want to know, she's in my face. I can't live like this. Let's take physical violence or, domestic violence out of the picture for the moment. And this is more of, we're arguing about money. We're arguing about kids. We're arguing about COVID. We're arguing about vaccines, whatever it is. The question that always comes out is, what do I do? Should I move out? And if I did or have or think about it, what's going to happen? But what do you say typically, Cassandra, to clients that talk to you about moving out?
I tell them, no, don't move out. And granted, as you said, the domestic violence issue is separate, but if there's no domestic violence, we always tell clients, do not move out, especially if you have children, because the ramifications of you moving out when you have children are that now she is a gatekeeper to those children, and she can tell you when you can and can't see them, which will affect your case down the road whenever you get to court. Right now, there's a backlog. So we're 3 to 6 months out. And if you haven't seen your children, especially the smaller ones, for 3 to 6 months, the judge is going to take that into account when he's ruling on your visitation schedule. And if you've already moved out, you haven't been a part of their lives, which also affects spousal and child support. Child support, you haven't seen them, your support's going to be higher because you haven't been there to be supporting them in the court's eyes. So we always say, no, don't move out. Do your best to move into a different room, have a better schedule, try to work out a schedule where you're going to be with the kids or you're going to be civil, but leaving the house means you're leaving your mostly number one asset behind. You're giving them exclusive use and possession of that asset and saying, okay, well, you can use this, and you may or may not be reimbursed for that. And then you're leaving behind precious mail, your documents, your things in safe deposit box, copies of your accounts, things that you are going to need through this divorce. So no, we don't want you to move out, and we want you to stay put because it keeps you on the same level playing field as your spouse.
Yeah, I think it's a conversation I inevitably have with every client that comes in the door. Even if they've made the decision to move out, and there's maybe a circumstance where we can get them back into the house. And I think, whether you have kids or not, it also matters. I'm curious your thoughts. And that is, I always say double household expenses. And that is inevitably something's going to go wrong. At the moment, clients have said, oh, we're getting along just wonderfully. I'm going to move out. I trust her. And I always paint this picture because, and I'll talk about the double household expenses, but they paint the picture of when you got married, you sat next to her, you're looking out at the crowd and your family, your friends, everyone you cared about was there to celebrate. But she's no longer next to you, not to kind of demean the situation, but the dynamics have changed. She's now across the table. She's going to look out for her interests, not yours. And inevitably something goes wrong. And even in the best wishes, the best expectations, something may happen where when I talk about double household expenses, that is you move out and her lawyer gets to her and says, look, don't pay the mortgage, don't pay the utilities, don't pay the car payment. And we're going to get to what do you do about money. But the point is now it's on you. And now you've got to pay for the home she's living in, perhaps with a boyfriend. And you got to pay for your 1-bedroom apartment that has no furniture. I mean, I see that as a potential liability when guys can't even afford to live in one home. Now they've got to pay for 2 and a lawyer. I don't know what your experience is with that.
We experience that all the time. And that's usually when the spouse has already moved out and they did the same thing that you said, is that they're like, oh, well, we agreed. Well, your agreement is only as good as it is until she disagrees and she changes her mind. And then that way you're paying spousal support, child support, all of the bills, all the community debt. And you have, as you said, your 1-bedroom apartment. So you can't have overnights with your children because you only have 1 bedroom and there's no place for them to be.
And she promised to let you come and say, oh, yeah, you can have all the visitation you want until she changes her mind. And now it's a whole different ballgame.
And it happens all the time. And that's the sad part is then, and a lot of times too, it's, oh, well, you get a girlfriend. And then, so then the dynamic changes again. And then they don't want you to visit because now they're mad and they're jealous. And now they don't want this girl around their children. And there's a dictation going on where you used to agree, but you don't agree now. So the agreements are only good if they're written and signed by a judge. Those are the only agreements that we want to work with. We don't ever move out without anything written for custody and visitation. If you want to move out and you have all these things agreed upon and the judge has signed off on it, great. But until we have these court orders, it's not a smart thing to go by word of mouth. In almost every state, that's not binding.
Yeah, I mean, there's a strategy to everything, and sometimes it's not an absolute no in every circumstance. It may be different based upon what's going on. I've utilized where I've said, stay in the house because you're going to wind up driving her crazy, and it'll actually lead to a better chance of settling this case because she'll just want to be done with it and then eventually have someone move out. I mean, that's a strategy that could be employed in making sure that it's not comfortable, because when you do move out, she has your home, your kids, your money, and why it's like a vacation. You're not there. And so I think it's something to really think about. And the custody thing, as you mentioned, is huge for me because I always say you're not driving the bus. You're a passenger, and she can dictate when and where and how often, how long, the conditions, whether it should be supervised. And it just is not. And now it's more money, right? Because you've got to file temporary orders, got to get court intervention. Remember, it's not necessarily uncorrectable. But it just leads to more attorney's fees when you make a decision that's not a strategic one, don't you think?
Yeah, and I think that the importance of meeting with an attorney is to make a strategy for your particular facts. Everybody's fact pattern is different, and we can't change facts, but we can work with the facts to make the best strategy for our clients, and that's what we routinely do. And sometimes it's as easy as saying, put off on talking about this, or we have a lot of military here. So, when they get orders, we don't always say, hey, we've gotten orders, because orders can always be changed. They're just kind of like a general, we think you're going to have to go here. So it's a strategy for every case that's very important to have an attorney to help you think of the 7 steps ahead that you might not know of, or you might not even have thought of.
Yeah. And then kind of the last part of this topic I always mention, because I think it is something that is well overlooked. And that is, when you do move out, it is most of the time, you're not going to be able to take everything you want with you. So that means some of the things that you value, whether it's things you brought to the marriage, whether it's personal items, personal goods, mementos, yearbooks, photos, albums, believe me, anything and everything that matters to you that you're unable to take with you because you think it's safe in the home is either going to be given away, sold on eBay. I've seen it set on fire on a video, on a doorbell cam, left out in the snow or the rain or whatever it is, and it's destroyed. And when it is given away, the testimony is simply, oh no, he took it with him. Now it becomes a he said, she said, and I can tell you what happens when he testifies versus she testifies, who gets more weight. And I think you all know how that would end. And it's not a good one. Personal property, if you want to watch over it, stay with it, don't you think?
Yeah, and you have to have it in your sight. And even when you're going to file for divorce, the best thing to do is have a plan of how you're going to make copies of that. A lot of people hide things. And if you have money in the safe, you want to take pictures, there's money in the safe. You want to make sure you have copies of things that are important, especially that are hers, because it takes more money for us to make her give them to us rather than us just making a copy and saying, oh, we already have it.
Yeah, it is. It's inventory is big, staying there. There are just so many reasons to have a consultation, make an informed decision. Most of the decisions in family law are based upon emotion and not logic. And so sometimes slow down, have a conversation. And ultimately, you may not follow the advice, but the point is you need to have the choices and understand what could happen. So, which brings up, and moving out kind of somewhat is connected, but really is, I'm going to go to Nicholas in Georgia, and that is big decision. She's left me or she's filed. Now I need to know, what do I do about my checking, my savings, my investment accounts, because you've got cash in there. You've got things. I know what her lawyer is going to tell her to do. And so curious, what should guys be thinking about checking savings and investment accounts?
Yeah, thanks, Scott. This is a great question and really important, because you may be talking about a couple different things. You may be talking about years of setting aside money, either in savings or in retirement accounts, things that you've earned over time that have amassed a lot of value. So that's kind of the savings aspect or the investment aspect. You also are talking about potentially your budget and how you're having to pay for things from month to month. And so a disruption to either of those things could be really detrimental. So it's really important, that you go, first of all, it's, state specific as to the laws, as to how you can maybe protect those types of assets. And they're also very case specific. So you definitely need to go and talk to an attorney about your specific situation and what you may need to do to protect those things. Generally speaking, though, there is a time component. Before anybody files for the divorce, you may not be under any specific rules as to what you can do with monies and accounts. And so there may be more that you can do at that point in terms of protecting those assets, starting your own individual checking account, perhaps, if you're concerned that your wife may be taking money out of the account and then you're not able to make ends meet, changing a direct deposit into your own individual account, just to make sure that that cash flow is still going to be there. But again, very important to get with your attorney and make sure that you understand what do's and don'ts are out there in terms of handling those types of accounts. Many states, I think, have kind of a look back ability. So one of the big kind of don'ts is don't start disposing and hiding assets, because generally speaking, these things are going to be subject to what we call discovery, where they're going to be able to be found out. Statements of accounts, where monies have gone. And so one of the big don'ts is don't just start giving your brother, cousin, uncle, whatever, all of your assets and think that you're going to hide it from the divorce court. You may very well shoot yourself in the foot by doing something like that, because then you've lost credibility perhaps. But there may be things that you can do, such as putting things into your own individual account that protects those things but doesn't dispose of them. Now, generally speaking, I know down in Georgia, once the divorce is filed, there is a standing order oftentimes that goes into effect, and that is county specific actually, or circuit specific in Georgia. So you'd have to check with your particular jurisdiction, but most counties and then state law actually prohibits the disposition of assets once a divorce is filed until that final disposition of the case. The idea being that the marital estate should essentially be status quo, except in the ordinary course of business. Of course, you're going to be paying bills, and so there are going to be some fluctuations in those accounts just naturally. But I'm talking about cleaning out an account and going out to Las Vegas and spending thousands of dollars unnecessarily. Perhaps those would be pretty big don'ts. But again, check with your attorney, see what your particular standing order says in your jurisdiction and any rules that may be in effect once that divorce is filed, and then you can come up with a strategy for best how to protect it. Now, ultimately, the court is going to decide whether these assets are either separate assets or marital assets. In Georgia, and I think generally speaking, anything basically that was accumulated during the marriage, except for very few exceptions such as inheritance and so forth, are going to be considered marital, whereas premarital acquisitions may be considered your separate asset. So looking at the timing of when the assets were accumulated is going to be important. And so that's, again, something where you're going to want to talk to your attorney about whether there are certain assets that you can completely protect from being divided. Because ultimately what happens is the court will decide, okay, these accounts or these monies in these accounts are going to be marital. That means they're subject to division. And then you need to come up with a strategy to try to get basically your best outcome if and when the court does divide those accounts. Title does matter, although title does not, in Georgia at least, dictate whether something is your separate asset or marital asset. Your retirement, for instance, a lot of people have kind of a misconception that, well, this is mine, it's in my name, it's always been in my name, and my wife's contributed nothing. Well, in Georgia law, if it was accumulated, if you're contributing to that retirement during the marriage, that is going to be considered marital and therefore subject to equitable division, which means basically that the court has discretion to determine how to divide it. Oftentimes it is an equal division. Some guys can't believe that their maybe lifetime of retirement savings could be split in half, but it's true. That's oftentimes actually what does happen. Now, again, there are things that you can kind of strategize about with your attorney, perhaps argue for an unequal division of that account. And that's where you really need to get into the litigation perhaps and find out what else is out there. Your wife, if she has retirement, for instance, or she has cash accounts, then you can participate in that discovery process that I mentioned earlier, where you're asking questions, you're subpoenaing documents, perhaps, you're asking her for documents, and you're trying to figure out what that entire marital estate looks like, and then coming up with the best strategy so that you come out of the back end of the divorce in the best position possible.
Doesn't it really come down to, when we think about checking and savings and cash, it becomes so important at times to be able to secure the assets if you're going to be the one paying the bills. Because I think the big fear is, for me, and it comes down to this: we have money in a checking account, and I'm curious your thoughts on this. She leaves, so I have a choice. I can take all the cash, I can leave all the cash, or I can do something different, and that is take half or some portion of the cash. And I know each of them have their disadvantages and advantages. And I'm thinking pre-filing, because there's always these standing orders that go into effect in certain counties that prohibit you from doing certain things like that. But I guess that, before filing, that really becomes the issue: is what do I do with it? Do I take it all and secure it? If she's going to make me pay the bills, why wouldn't I take it all and open up a new account? Or I take a risk and I take half, or I take a huge risk and I leave it all, and I know her lawyer's going to say, go grab it all. So I don't know what you think.
Yeah, that's a great question, Scott. And to me, it's really fact specific based on the particular situation that the client is going through. I think part of it depends on of course, first, is the account a joint account? If it's not a joint account, then obviously you may not have to do anything. If it is a joint account, then I think you have to get into what is the purpose of the account. If it's, for instance, an operating account, like a checking account where checks are being direct deposited, whose checks are going in there? If it's only yours, if it's only the husband's, then yeah, he may very well want to take all of that, especially if the wife has moved out, and he's therefore responsible for 100% of the bills. He may very well want to move all of that into an individual account where it's protected and he's direct depositing, so that he can ensure that she's not going to periodically come and remove money that you're depending on to pay bills. You're just ensuring that budget is continuing to operate the way that it has historically. If we're talking about a kind of a non-operating account, such as a savings account, for instance, it is still a liquid account. If it's a joint account, I think depending on the situation, again, you really need to get with your attorney. I think I've probably advised it both ways, depending on really the overall picture. If there's a real concern that the wife may just empty it out, for instance, then you may be more inclined to either move all of it, or maybe you just go ahead and move half of it and say, okay, we're just going to kind of act like we're preemptively dividing this, because that's probably what the court will do anyway. And in any event, probably not going to be worth fighting over ultimately if she takes the other half. On the other hand, I've had situations where clients come in and it's a lot more sensitive, and the client may be very desirous of having a quick settlement, and maybe the wife is open to that. But if he clears out the savings account, she's going to run to an attorney and they're going to start getting super aggressive because they think the husband's doing something wrong now. And so again, I think it's just you have to have, as an attorney, kind of a sense of what's going on, and kind of listen to your client and get a feel for what his best interest is. And then, explain what the risks and rewards potentially of his different options are. So yeah, it's a great question. It's definitely something that you really need to get into, if not in the first consultation, pretty soon after you start talking with your attorney.
Yeah, I think it's really important, because Inevitably in family law, there's surprises along the way, and you'd like to limit and minimize those. And this could be one of those where you just at least have a conversation. I can tell you that I've had clients come in, they didn't come in quickly enough. Wife left, they decided to wait, they delayed, and they've come in and said, look, I just checked my bank account and I have 10 checks that bounced because she withdrew $5,000, all of it. And I've got like nothing left. What do I do? I said, well, we're in trouble now because obviously we have to go file motions and try to recover some money and get her on the hook. But that's the point, is if you can take some good steps in advance, preparation, conversation, you can try to really push this off and avoid some of these. So, which leads us to the next one, Rebecca. You know, the big question I've talked about a lot. I have my opinions. I'm curious yours. Does it matter if I file first? You know, guys ask that all the time. And I have experience and been doing this almost 29, 30 years. And there's some early 90s law that always influenced my decision. It's no longer law, but it's worthy of talking about. But what do you think? Does it matter if I file first?
Well, like many questions with family law, my answer is going to fundamentally be it depends. That's a very situation specific question. There are, from what I understand, some states that potentially there is some legal ramifications for being the first to file. Maryland is not one of those states, and I'm not particularly familiar with those. In Maryland, it's more a strategic question. So one of the things that you're going to want to know is, let me go back a bit. Talking to an attorney is something that should be happening before you even start making any single moves. As Scott said earlier, there is so much strategy involved, and even the slightest change, the slightest move can impact that. And I frequently tell my clients to think of everything as a chess game. If you know divorce is coming, it means you're setting up the board. Nobody's really taken a lot of steps yet. You want to have your strategy in place before you take the first step. And frequently, filing is not actually the first step. The first step is a lot of the questions that have already gone over today, and things like what Nicholas talked about with regard to setting up finances ahead of time. So the issue of whether or not you should be the first to file is something that you need to be working with your attorney very closely on. I'm just going to give a few examples. The other thing that really needs to be factored into that, though, is whether or not that could potentially trigger any support issues. So if you happen to be the spouse who needs support, filing sooner may be better for you, because especially in Maryland, any child support or alimony could potentially be backdated to the date of filing where it was requested. Conversely, if you are the spouse who is hoping to not have to pay support, by filing first, you may be the person that triggers that date. So you want to be very careful about what triggers you may be pulling with regard to the timing of when support, either child support or alimony, could be backdated to. The other thing you want to think about is, how is this going to play out in trial? The question of whether you should be the first to file sometimes doesn't come to fruition until your case actually goes to trial. So it may be something that is given a lot of consideration at the very beginning, and then you're not seeing any result of that until later. And that's a question of presentation. If I have a client who maybe has some bad facts, some things that are not going to sit very well with the court, it may be the strategy to have my client come clean with all of those. Have him tell the court those stories first, so that he or she is able to frame them in a way that takes the power away from the other side and presenting it. So that's something that you want to be thinking about with regard to your filing. There's always going to be appearances that you're going to have to consider. In Maryland, we don't frequently know our judge until the night before the trial. So trying to gauge how a judge specifically is going to react to first to file versus waiting to file, that's something that we really can't weigh. But I know, Scott, that you guys know your judges in advance. So this is, again, another really important reason for consulting with an attorney who is familiar with your state, and ideally familiar with the very specific county or commonwealth that you may be filing in. The worst possible thing that you can do is get advice from Google or get advice from well-meaning friends and family. They're going to have good intentions, but it's not necessarily going to be advice that is applicable to you, applicable to your state, or applicable to your county? So it's a great question. You need to know an answer. You have to talk to an attorney.
Yeah, I wholeheartedly agree. You know, it is, you know, when my friend's brother's brother-in-law has the same issue and got a different result. Why not mine? And I think it's like cancer. You know, cancer is treated differently every time, and every doctor goes after something differently. There's little, you know, elements of every case that matter, whether it's the county, the judge, the opposing counsel, behavior, whatever it is. But filing first is always something you must consider. You know, as you suggest, presentation's a big component. But again, everything we talked about here is about kind of just having that strategy discussion, trying to determine what really is right for me. So, Matthew, going kind of as we keep going through, what do I say to my wife? You know, talking too much can be a negative. You know, depending upon the situation, what do you say? You know, if she's left, what do you do?
Oh, that's a great question, and of course, just to follow in Rebecca's footsteps of, you know, the common lawyer answer, it depends. Everything's factual specific, and if the question is always that I ask is, what is the relationship between the two of you? Is it you're out of love, or are you trying to work things out? Have you tried previously to work things out? I have several clients all the time that want to stay in their marriage, and unfortunately, they haven't had the opportunity to really fix what's wrong or where that breaking point was. And so in Missouri, at least, the standard of, you know, what needs to be claimed or alleged is whether the marriage is irretrievably broken. And so, you know, if you're trying to stay in the marriage and the two of you aren't, you know, fighting like cats in a wool sock, you're trying to make sure that, you know, you can stay together and going that standard and trying to stay together by, you know, entering therapy or anything like that. But the ultimate thing I always tell my clients is, you know, if you're able to communicate and you can come to an idea of what like a parenting plan might look like, start practicing that parenting plan. If you've not moved out, you can figure out, you know, on Mondays and Wednesdays I pick up my kids. Those would be the days that I'd want to do that with a parenting plan. It works with my work schedule and it works with the children's work, or sorry, your spouse's work schedule. But the key thing is, and what always falls apart in these things, is communication. So if you have a sit down, they've left, you have a sit down, and you can decide, you know, who's paying what bills. That also is a great assistance. It prevents the idea, or, you know, the accounts being drained, those checks bouncing, and everything like that. So that's what I always try to tell my clients is, if you can communicate effectively and have an idea of what you guys can do together in order to, you know, move the case towards a peaceful but also, you know, reasonable resolution.
And, you know, I think what's also something to think about is strategy. I was trying to think of an example. You want to get along, you want to try to facilitate things being mutually beneficial, and you want to and try to progress. But I think one thing I would mention, and I'm curious if you've run into it, is talking too much about strategy that you meet with your client about. Hey, we're going to get an expert, or let's go ahead and send this discovery, or I want you to not move out for X reasons, or I want you to go take 50% of the cash. I mean, I think strategy's got to be a huge consideration of how much do you share. Now, keep in mind, I say you talk as much as you want about the kids, health, education, welfare, right? But it's really more about positioning yourself and not sharing the strategy.
No, absolutely. The one thing you don't want to talk about is what your plans are, or especially what your considerations or conversations with your lawyer have been. If you've been meeting with an attorney, you have a plan in place, you have that strategy. The last thing you're wanting to do is, first of all, the problem would be by going into what your attorney's told you, you may have violated the attorney-client privilege. And if we've violated the attorney-client privilege or broken that open, it creates a problem in which our strategy, or the strategy that you discussed with your attorneys, is kind of fair game. It's open. They can then send you a discovery request to ask for, you know, your notes, your conversations, and everything like that. And so instead of saying, my attorney told me to do this, you can instead move forward with those things, but also see what they're wanting to do. Because in that same by that same token, they're also going to release some of their strategy that they talked to their attorney about. So always make sure that it's when you're discussing those things, you're not discussing your strategy. You're not going to the open thing of, well, I'm going to take this retirement account, unless they're offering that retirement account. Then, you know, that's a good way to look at it. But never go into the details of your strategy or your next steps, because like we've been saying, it's a chess game in that sense.
Yeah. Well, Matthew, I'm going to stay with you. We're going to kind of skip up a topic to try to move things along. One lawyer. It's always comes, and I know, Nicholas, I want to hear your input too on this. It's common where I have a client now that says, hey, she says we should just use one lawyer. What do you think? And man, red flags, crazy. What do you guys think? Matthew, start with you.
I can sum it up pretty much with the one word, and that's no. I can say it again. It's no. The problem with it is, if you have your one attorney who's met with both of you, discussed it, that attorney has to represent one of you. And if the attorney's representing the other side and it does turn adversarial, now you've got an issue in which you have to hire another lawyer, and you're back to fighting. And this attorney knows your weaknesses, they know your strategy, they know everything. So using one attorney is never advisable, is what I would say. Just because at the same time that if that attorney is drafting those documents and winds up representing the other side, then those documents that you haven't had a chance to review, you haven't had the guiding hand of counsel to get those things, across to you, it creates that issue. Not only that, for an attorney, it also can create a conflict of interest, especially if the parties do, become contentious, or, they start to disagree. So it puts everyone in a bad position to split the one lawyer. I understand that, the fees are a pain to eat, but it protects you in the back end, and also, keeps everything on the up and up.
Nicholas?
Yeah, I'm just going to piggyback kind of off of what Matthew just said. Absolutely not. I mean, in Georgia, and I think probably most states, it's actually ethically impermissible for one attorney to represent two adversarial parties in the same matter, right? So that attorney literally cannot advise both you and your wife simultaneously. And what that means is, if your wife has found the attorney, it's very likely that she's already established that attorney-client relationship. And if that's true, then that attorney literally cannot advise you at all on how to protect your interests or what you should do. And, while that attorney should tell you that, some attorneys may play a little fast and loose with that disclosure. And so you need to know, kind of going in, there's no such thing as one attorney representing both of you. And so if that attorney has already met with your wife, that attorney, you need to assume that attorney represents your wife. You need to have somebody on your side of things that can actually advise you, read over any documents before you sign, and tell you how to best protect your interests. And the results can be just terrible. I've seen too many situations where someone has been under the false impression of the wife's attorney representing them, and then they trust what the wife says. Oh, this is what's going to be in the agreement. They go to that attorney's office. They may kind of breeze through the agreement, just trust that everything's going to be exactly as has been said, and then they sign. Well, when that happens, you're stuck. There are very few ways to get out of a signed agreement. It's very rare. And saying that you didn't understand that the attorney didn't represent you is not commonly a way that occurs. So on the front end, avoid that, get your own consultation with your own attorney so that you'll be protected.
Yeah, I wholeheartedly agree. I mean, I know when we are on the end of, we're the one attorney, we're drafting all the documents and the spouse isn't hiring, I am intentionally drafting the provisions that are very pro our client, and knowing full well that I'm trying to get something by the other side, because they don't have legal counsel. And so if you're watching this, know that the other side's doing to you exactly what we would do to them. And so it means that everybody should just have a lawyer. We're not going to give them advice, but what we are going to do is put provisions in the agreement to your advantage, and maybe something that we know that they'll overlook. And so it's just, and as we start out with Matthew saying, I'm going to answer it, and that's simply no. The answer is no. It should never be anything but no. And have that consultation. And the worst, or I guess the least thing you can do, is have those documents reviewed. But I even then, attorneys have limitations when they're just reviewing documents, and you have to be very, very careful. So, all right. So we have a bunch of questions that have come in. So I think we're just easier to jump right to those because we want to get some of those questions answered. So which means we're in our lightning round. So we're going to go ahead and toss the questions that have come up. We'll go down our list and see what we can get through. We have about 15 or so questions. So we'll get through those in the next 10, 15 minutes. All right. So Matthew, just start with you. There's someone who's attracted to Cordell Cordell for specialization skill set, for the fact that we just do family law and representing guys. How does it apply to this client who has 3 kids, a 19-year-old with special needs, 17 and 13? And what is it that particularly makes us more attractive to a client with kids and maybe even one that has special needs?
I think one of the things that works really well with Cordell is, of course, that specialization. All of our attorneys are experienced in family law and can also understand. I think most of the attorneys in my office are parents, and so we understand not only that this is the hardest thing that you're going to go through, but to have children and be going through that, the time that you're going to spend away from your children, the uncertainty, all of those things. We're there to help you and guide you through those obstacles. And it's one of the things that I take pride in with this firm is that specialization, and also just that empathy and understanding, and making sure that we can help you take better care of your children and keep you in touch with them.
Yeah. And I think one of the things that I love every day, in that 300 lawyers around the country, is we share questions about cases and strategy. Like, okay, here's what I've got to answer this question directly, is the power of 300, not just 1 or 2. And that is, every day there's something that goes around, say, I've got this issue, give me your ideas, give me your thoughts. What do you think of this strategy? Do you know something that I can do here? And you're getting a lot of responses. So it's the beauty of having the experience of all these lawyers across the country, and providing some insight. And I think that's the value of Cordell Cordell. It's not just one lawyer shop over here, or some of our offices have 5, some of them have 20, some have 1. And I think that's the beauty. And some of them, particularly in Texas, have board specialization and certification. That's huge, which means they're an elite class of attorneys in the state of Texas. Kelly Burris's example in Texas, board specialized certified. I think it's like 4% of the attorneys in the entire state are certified. That's the advantage of Cordell Cordell. So, all right, let's go on. Nicholas, Charles over in Nebraska. He's been married for 18 years, but been estranged for 15 of those years. However, they recently moved back together, either in the last 4 months or for 4 months. He wants to file for divorce, but the question he's got is whether or not he'll be obligated for alimony if she doesn't work. So it appears that they've been married for 18 and haven't really did anything in those 18 years, even though they lived separate and apart for 15, back together for 4 months. And I know Atlanta, you can give us, in Georgia, kind of your thoughts on this, even though you're not in Nebraska.
Yeah, this is great. I love this question because it really shows how unique everyone's situation is. I don't know that I've ever heard of a situation quite like this, not with just the long period of being estranged, but actually coming back together after a long period. I've dealt with cases where you have even a decade or more of being estranged, but typically they're just, finally doing the divorce after that long period. I don't know that I've ever seen a case where you've got more than a decade being apart and then back together for a short amount of time. Now, having said that, alimony is a claim that the wife could potentially file for in Georgia. And again, every state is different. I hate to say it like that, but it's just true. You would really need to talk with a Nebraska attorney to find out exactly what the law is there. But I think, there's certainly some similarities between states and how they handle alimony. In Georgia, the way it works is it's a viable claim in that situation, which means she can ask for it, but then it is a discretionary determination by the court. There are a couple hard and fast rules, what we call bars to alimony. One is that if the asking spouse, if the wife has committed adultery and it's the cause of the divorce, then that spouse is barred from obtaining alimony. So that's a question. Other bar is what we call desertion of more than 12 months. So that's kind of interesting in this fact pattern. You clearly may have been able to easily make out that case for the years that you were apart for so long if you weren't supporting her during that period, which is another fact-specific thing that you need to get into to really analyze it. Having come back together for the 4 months, though, presumably there's a new cause of the divorce other than that desertion if you've gotten back together. So it may be then that that desertion bar does not apply, but again, talk with your attorney about what you may or may not be able to do in that regard. So then the cause of the divorce is going to be important. If there's not a bar that applies, however, what the court does in Georgia is it looks at different factors. Some of the factors include the history of dependence on one spouse by the asking spouse. So again, whether you supported your wife during that period of estrangement may actually come into play. If you didn't, I would say you're more likely to get either a lesser or no alimony outcome, although there are other factors to consider as well. Another one is the discrepancy in the incomes. Do you make a lot more money than she does? If yes, then you have a larger target than if you make about the same. The duration of marriage is another one that kind of has a unique application in this case. So you have kind of a long marriage. However, you have most of it being apart. There's not really a calculation method in Georgia to say, okay, well, if you're together X amount of years, but you're apart, or you're married this amount of years, but you're actually apart this other amount of years, that equals some specific duration of alimony. It's all discretionary. So basically, there are arguments that you're coming up with based on the evidence with your attorney to try to minimize your exposure to that alimony claim if and when the wife does ask for it. So, for that reason, again, you're wanting to get with your attorney, you're looking at your specific state's law, you're analyzing the facts, going in depth with that attorney on how those factors may play out, and then trying to basically get the lowest award possible.
Yep. All right, let's go to Cassandra. Michael says, when I got divorced is a tough one situationally. When I got divorced, we signed saying the amount of alimony could not be changed. Since then, COVID hit, and of course, I own a restaurant. I've fallen behind by quite a few months. I do send something every month, but I can't pay all of the amount due. Do I have any chance of getting any relief whatsoever from the courts?
So in California, this one would be interesting. We would need to read the judgment or the document that you signed to see if there was anything in there that would help you. Most of the time, the judge will say you've made an agreement, you've made the stipulation. That's why we generally don't like to agree to non-modifiable spousal support or child support because of these things. You never know what's going to happen. And so non-modifiable is great in certain situations when it might be short term, but when you are doing non-modifiable and you're not setting a time frame of when that is going to be, we really have to look at the rest of the documents to see if you're going to have a chance for us to take this to court to say, Your Honor, this is what happened. This is the clauses in here that we believe make it so that we can, change this or modify this.
Yeah, it's a tough one. I think when you look at it, especially, that's the dangers of kind of a fixed amount or fixed term duration, non-modifiable. It's very difficult. The issues of contempt come into play. I would encourage you to come in, have a consultation with one of the lawyers, at least know where you're going to stand. I'm dealing with a contempt situation very similarly, where our client cannot afford to make the payments. And I think we're going to be successful in keeping them out of contempt just by situationally, especially COVID. So it's certainly worth a consultation. Rebecca out of Maryland, Damien in Maryland has a question. My wife left, didn't take the kids, and no mention of them coming to live with her. Now she's claiming they live in both places. We're going through custody now. She sees them every other week. Does Damien have good standing and to get custody?
So obviously, Damien, if you were here, I'd have a couple follow-up questions for you. When you say that she gets them every other week, are you saying that she has them with her every other week for a full week? Or are you just saying that she's seeing them maybe every other weekend? The two would have very radically different outcomes. Let's assume that it's an every other weekend situation. The status quo is something that's very important, specifically in Maryland. So it becomes a question of whether or not you can show that. So I would urge you to come in and talk to us, but also take a look at your text messages, your communications with her, anything that you might have that shows the actual time that she has with the children. She can claim whatever she wants in documents with the court, but when you're finally in front of the court, that will be your opportunity to show either she is being untruthful with the court, which would be hugely helpful for you in your case, or if she is actually seeing them every other week, that is something that sets up a status quo that's more like a shared physical custody schedule. So I would urge you to give that 1-866-DADS-LAW a call, get in, let's have a consultation.
Yep. I'm going to stay with you, Rebecca, on this question from Andrew in Florida, though. Married for 11 years, wife plans to file for separation or divorce. She plans to take the kids and move back to Ukraine, where she is a citizen, and change their citizenship to Ukrainian. The question is what should Andrew be doing? How hard would it be to get the kids back to the U.S. from Ukraine? And I know Ukraine particularly is has the treaty agreement under the Hague with the United States, but trying to invoke that is even often difficult. Just curious your thoughts on this. I have a 10-second thought as well.
Don't let your kids leave. That's the simple answer. Do whatever you can do to keep them in the country. Even any country that's a member of the Hague Convention, at least you have some hope of getting them back, but that hope may look like 5 to 10 years in order to get that done. So whether or not they're even children by the end of that time is a big question. A lot of states have emergency custody petitions that you can file. A big one would be, at least in my state, a big trigger would be, hey, she plans on moving the children out of country. Try to get it in writing, try to get a text message, try to get an email. You need to be seeing an attorney as soon as possible. You need to be talking about getting that done and getting that done right away.
Yeah, steps to prevent, filing first, doing anything, TROs, restricting the ability, getting custody of the passports, whatever it may be, because once they're gone, it becomes immensely more difficult. So Nicholas, kind of along the lines we were talking earlier, I think this is Ted, has self-employed, spouse is not on the business formation docs. Can I move an account to a bank that she doesn't have access to and be restricted from access, even if we're still legally married? The question is just, can you move a business bank account over to another account?
Yeah, I would say, well, at least again in Georgia, if you've got nothing filed in particular, then there's nothing that's going to restrict you from moving funds over to an individual account, especially if you're concerned that your wife may tamper with the account, remove funds, and potentially disrupt your business operations. I think that one, you certainly need to get with an attorney to come up with a game plan moving forward. But I think generally speaking, if you need to protect funds in a business account from potential sabotage from an angry wife, for instance, then that's something that you would generally be able to do, at least in Georgia.
Yeah. All right, I'm going to answer a quick one as we keep going through these. The question was, what can I do if my wife accessed my personal account and withdrew almost all of the money? I know we talked about the decision making. If you don't have that, if you leave it all, she takes it. If there's an action pending, if you filed for divorce and it's in the middle of the divorce, you're going to want to go ahead and get your attorney to file a temporary motion, something to bring that to the attention of the court and to get that money back, or at least put them on the hook for it or account for it. But it's take action now. Don't let time continue to move by. Have your attorney file something with the court. All right, let's go to Cassandra. Let's see. This is from Alex. My wife and I are doing a trial separation. She signed a 6-month lease and is moving into a house about 3 blocks away. We have daughters that are 6 and 4. My question is, what state or odds are available for trial separations when the couple ends up getting back together? Or what are the stats and odds getting back together? In your experience, who typically files first when the wife moves out? So let me go back. The question is, what are the stats odds for a trial separation when the couple ends up getting back together? In your experience, who typically files first when the wife moves out?
So the stats and odds of a trial separation really all depend on the people. How badly do you want to work it out? How badly are you going to work it out? How badly is she? Are you going to do the steps that you need to do to work this marriage out? It's not necessarily something that we're ever going to be a part of. We are going to sit there and be there for you if you need us. As divorce attorneys, we're not hoping you get divorced. We're just here for you when that happens to you. And so I have seen personally multiple clients be able to move forward and reunite and then move forward with a healthy marriage. And what it is us being here to help you know what you should be doing and what you shouldn't be doing and be smart about it. But we always want our clients to be happy. And if you can be happy with your spouse, then that's even better. And usually in my experience, when a wife moves out, it's her that's filing quickly, because if you're moving out, most women don't want to move out. And so if they're moving out, then there is some sort of urgency for them to get this moving along and get this filed.
Yep. All right, Matthew, let's go. Question is case is on hold, waiting for the two parents to attend co-parenting counseling. Husband is the non-custodial parent and would like to get son into counseling due to some alienation. The mom is not on board with getting him into counseling. GAL has not done her due diligence and is on mom's side with one 15-minute call with father. We're 1 year in the case. We want to keep things moving. How can we get the ball rolling? We'd like to hire a custody or get a custody evaluation. So case seems to be kind of just moving nowhere, spinning tires, some alienation issues. Guardian seems to have just done a little bit of work. What can they do to get this case moving?
Yeah, typically, depending on the age of the children, of course, with counseling, you got to push back on that guardian ad litem. Getting in touch with them and letting them know your position and why, and figuring out why they don't want to go with the co-parenting, or I'm sorry, the counseling. If that's the case, the guardian ad litem is not really giving you any kind of indication as to why and hasn't really put the work into it. It might just be best to file something with the court to get that or make that request to get an order for the child to go into therapy or counseling. The only reason you would want to, or one of the reasons you want to do that, is to get it to the attention of the judge that, you know, you're having issues with this guardian ad litem, or you're having issues with the mother and having, you know, issues with the co-parenting and that legal custody portion of it, where, you know, the two of you are supposed to, under the idea that the perfect world of default of legal custody is that the two of you can work together on, you know, major life decisions for your children. One of those would be counseling, and I can say that at least in my area of Kansas City, if I'm going to file a request to have a kid go into counseling, that's more than likely going to be put in place, just because the court understands that the divorce itself is not only hard on you, but it's also very hard on your children. And, you know, it's becoming, at least in some courtrooms out here, almost a de facto decision that, okay, we need to get the kids involved, especially when a guardian ad litem is appointed, that we need to get this kid into therapy or counseling. And, you know, even at the ages as young as 4, I've seen, you know, they're doing play therapy just to get away from that piece of the separation of the marriage, or the dissolution of the marriage. And, you know, so I would say the best way moving forward into a situation such as that is to push it on the guardian ad litem, get that piece done. And if the guardian ad litem is really just not pushing it forward and you think it is in the best interest of the child, make the judge make the determination.
Yeah. All right, we're running out of time, but I think we can take one more cast. Raymond's been married 17 years. Wife makes more since 2016. Before then, he paid 95% of the bills. Once she started working after school, she started taking money out of the account and opening various accounts. She refused to pay bills, works extra shifts. Now wants me to remove my name from the account she originally owned. They have 4 kids. Oldest is 15, youngest is 8. How will this all work in divorce? And what about properties outside the United States that she never contributed to that he owns? I don't know the state, but you know, you got a little bit of issues here.
So this one's one of my favorite scenarios and fact patterns, because people think that just because they open their own account, that's their money. So she may not have been paying bills, but any money she's been squirreling and hiding away is still half yours. So you are in a position where she thinks that she has this nest egg that's just hers because you've been paying the bills. But because you've been paying the bills and you're married, that's still your money. And so what will happen is that in the division is we will get access to her statements, and the judge is going to say that's half yours as of the date of separation here in California. The other issues you brought up about how it taking your name off of the accounts, I would never suggest you do that. You want access. I would suggest you go through and you print out all of the statements to have those, to see any transfers. Make sure you point those out so you can prove, you know, when she's transferred money, and you can find out where this money went. And when it comes to properties outside the USA, it doesn't matter where the properties are. They're still marital properties. If you had purchased that before marriage, then there is a claim that it's your separate property. If it's something you purchased during marriage and you've used marital money for, then that's going to move more towards that being a marital property, even though she didn't contribute to it. However, the other issue with her making more and you have a long-term marriage is spousal support. That's coming your way at this point, along with a larger child support, depending on your timeshare with the children. So you're not in a bad position with her making more than you at this point. It's going to help you.
Yep, agreed. Well, unfortunately, I know we have a handful of questions still in there. We'll address those at the next podcast. Love to have you tune in, subscribe. We'll get to those questions in the next podcast. Go to Apple iTunes, and it's the Men's Divorce Podcast. Love to have you join. We'll answer those remaining questions, and that is all the time we have today. We want to make sure we respect your time and end as close to on time as possible. So thanks for joining. Keep looking out for the next virtual town hall coming up in October. Check us out on the web at CordellCordell.com. We also offer virtual consultations. If you don't want to come in, you can do that by calling 866-DADS-LAW. And I know with a lot of the individuals that we answered questions, we have offices in Texas and Virginia, in Charleston, South Carolina, in Nebraska, all around you throughout the country, including the United Kingdom. So until October, have a great weekend.